When co-owners of land reach a disagreement on whether to buy out one another or sell that property and split the proceeds, they often turn to partition and sale of land, a legal remedy used as the result of a poorly planned farm estate. Joining us now is Roger McEowen with the Washburn University School of Law. Thanks so much for joining us, Roger. And let's start with some background on the partition and sale of land and how it typically comes about.
Well, Christina, good to be with you today. And it usually comes about as a series, as you indicated, of really poor estate planning decisions that have been made or no decisions at all. And so what happens at the last of the parents to die is that the farmland simply goes to the kids and it's divided equally amongst the kids in undivided interest. So they each end up owning the whole thing, but an undivided interest in the whole thing. And the problem is that if one of those kids wants to continue the farm or the ranch, and some of them don't want to do that, the ones that don't are going to want to get their money out of it, but yet the other one doesn't want to have the property sold or to be fractured. So it creates an absolute mess in many estate planning situations unless you plan to avoid that. So,
Roger, is a partition an exchange?
Well, that's a good question, because if it is an exchange, then we can treat it under the like-kind exchange rules. And Congress left those intact for real estate. If it's not an exchange, however, it does not need to be reported to the IRS, and we don't have to worry about related party rules. And the key here is whether the properties are similar or dissimilar. Can we split this all up, and do we have similar properties? Are we just rearranging ownership amongst the same ownership group? If we are, then there's no tax issue that's involved.
Okay, let's talk about the tax consequences that do result, though, from a partition or resulting sale.
Yeah, basically, just kind of to go back to what I said, most of the time we don't have to worry about tax consequences on these types of deals, because if we've got, say, three brothers or brothers and sisters, and they each have an undivided interest in an entire tract or in separate tracts, and we want to rearrange those ownership interests so that, say, the farming heir has a particular tract and the non-farm heirs have a different tract. So we're just separating out ownership interests, and we're not dealing with any debt on the property. There's no loans that are involved, and we're just rearranging ownership. Then there's no tax consequence to that, and that's a very important point to keep in mind.
Absolutely. You're really great with examples. We don't have a lot of time, but can you give us some more perspective with one of your examples?
Yeah, IRS has ruled on this and has given us really a couple of guideposts over the past 40 years. And in one of them, they had three brothers that each held an undivided interest as tenants in common in three separate tracts. And again, there were no mortgages that were involved, and they agreed to partition their ownership interest, with each brother exchanging his undivided interest in the three separate parcels for a 100% ownership in one parcel. So they ended up each with their own parcel, not with all of them having ownership interests in all of the parcels. And the IRS said no tax consequence to that. And that they've had some variations on that set of facts over the years, but basically that's the key point that we want to get across to people today.
Again, we always thank you for making us smarter. Roger McEowen with the Washburn University School of Law, thank you so much for joining us today.